Recording in progress.
Molo buhle, Alan, how many members are in the platform? I'm here. Honorable Maviletsa is here. Honorable Manye. Yeshua, munam tamti mweshelo.
Angeke iheshe lata bona iheshe
Hey, kale man. Okay. Maviletsa. Kasani is here. We're five. Butle,
Dad,
are we five?
Dad,
Shotambo Noxi was here earlier on. Maviletsa, can you quickly check
Okay.
Comrade Noxi and Maswale? They were here earlier on.
Yeah.
Okay, thanks.
Tata, joina uMamNkomo.
Ubani joining?
uMamNkomo.
Where is she? Oh, Honorable Sanele Nkomo. Mazet,
Yes, Chairperson.
kunjani? I saw you were busy namhlanje.
Yo, it's hectic. As on my side, now I must join strategy. I don't know what I'm going to do for a debate in 16 days.
I remember when we finished this, you go join another strategy.
Yeah, no, I'll wait.
Yeah, hey, so we are correcting now, Panamash.
Tata, we are.
Okay. Thanks very much. Alan Butle, can you flight the agenda? In the meantime, let me officially open the meeting of the Standing Committee Finance. This is the second meeting today. And welcome everybody, welcome honorable members of the Standing Committee Finance. Welcome officials from Treasury. Welcome our guests from our colleagues from the Competition Commission, Financial Sector Conduct Authority. It's quite some time that we have been engaged with you. We hope to see you before Parliament rises, FSCA. Welcome, National Treasury. You're welcome. Let me welcome all other entities that report to Treasury, if they are here in the platform, and parliamentary divisions. I see Parliament TV is here. Legal, PBO, all of you who are from Parliament, you are all welcome. Today we have called this meeting, honorable members, to deal with the matter of public interest, which is the currency manipulation. We have invited the Competition Commission, FSCA, National Treasury, South African Reserve Bank, and the Banking Association. So far, we have received an apology from the Banking Association that they've got other business. They won't be able to attend this meeting. And we have received, I think, also an apology from the Reserve Bank. I think we'll come to that when we come to item 2. So we have invited these stakeholders to brief Parliament about this issue of currency manipulation. This is a matter of public interest. On the 15th of November, the Competition Commission issued a media statement entitled Multinationals Standard Chartered Bank Admits Liability to Currency Manipulation Case and agrees to pay 42 million fine. This matter has also been raised in Parliament through statements by honorable members. We are quite interested on this matter as a public representative because it has had serious impact on the economy of South Africa, which is struggling as we speak. So it's not a matter that we can just look at and see the statement there and not engage with it. We welcome what the Competition Commission has done, because there are so many banks that you are investigating or that have to appear before you. And it looks like majority of them are international financial institutions. So we understand that also there are outstanding issues that you are dealing with. You also indicate that there are these cases which are what do you call it in legal language, sub judice, so that we don't go into such areas. So you will guide. I see Honorable Manye. Honorable Manye, you said there's somebody from Reserve Bank in the chat here. Okay, if they are here, they are warmly welcome. So, as it is in the agenda, we'll expect the Competition Commission to lead by giving us a briefing, and then come the FSCA, which has got a responsibility to deal with financial oversight on institutions that are in the financial sector. We get the input by National Treasury. The Reserve Bank is not here. I'm not jumping the gun, but the Reserve Bank is very important. Probably we'll have to have another meeting at some stage for the Reserve Bank to appear before Parliament to explain to us as to what did they do in this regard, because they have got a responsibility to issue out licenses to the financial institutions. If the Reserve Bank is ready, we can so also give them a space after or before Treasury. They can indicate and make a presentation about this matter. Then we are going to take item 6 to be number 7, somewhere there, where members are going to engage the presentations. Let me find out from the Secretariat if there are apologies.
Good afternoon, Chair. Yes, apology received from Dr. George.
Okay. Apology from Dr. George is noted. And then Alan Bushle, let's find out, is Reserve Bank ready to make a presentation so that we can change the agenda accordingly, or they will let them come after Treasury so that they be preparing themselves now that they are here. So amend the agenda accordingly. And we have dealt with apologies. Let's also welcome our colleague, Honorable Shivambu. We have been seeing you for a long time. We have got Honorable Manye here, who is very, very active.
Yes.
Yeah, me busy as you are with the election. And I'm going
Yeah, I got push. Look, Louis.
Hey, no, you are welcome. Okay, let me not take much of our time because it's Friday, it's getting late, and invite Competition Commission to make a presentation. Over to you, Competition Commission. I don't know who's leading. The leader of the delegation will have to introduce him or herself, and also introduce other members of the commission. Thanks very much. I see somebody raising a hand here. Olanu Makuele. Okay, there is a hand that I see, Mr. Makuele. Before I hand over to the commission, I see you are raising your hand.
Yes, thank you so much, Chair, and good afternoon, honorable members. Chair, we just wanted to kindly request if you could accommodate us in the agenda by swapping the FSCA with the National Treasury. So if the National Treasury as the policymaker can go first, Chair, and then we will follow them if it's acceptable to yourself, Chair. Thank you.
No, okay, no problem. Okay,
Thank
let's
you,
go. Let's go back to the Competition Commission. Please introduce yourself and the team that you are leading. Then you make a presentation. Over to you, Competition Commission.
Good afternoon, Chair and honorable members and other colleagues. My name is Doris Tsepe. I'm from the Competition Commission. With me, Chair, I'm joined by 3 of the Deputy Commissioners, Deputy Commissioner Bake Majenge, who's an acting Deputy Commissioner, but also Chief Legal Counsel for the Competition Commission, Deputy Commissioner Hardin Rachisusu, Acting Deputy Commissioner James Hodge, who's also the Chief Economist for the Commission. And I'm also joined by 2 of the divisional managers, Mr. Makale Muthala, who is the divisional manager responsible for cartels, and the divisional manager in the office of the Commissioner, Mr. Andile Kwabeni. Thank you very much, Chair, for inviting us to come and speak to you on this important issue. Chair, due to time constraints, we were only able to forward the presentation from the Commission late this afternoon. I hope you were able to receive it. But what I will do right now is I will share it on Zoom, and hopefully technology will allow me to do so. But that's so I can take you through the presentation. I hope that's fine, Chair.
You have muted yourself. Are you sure you want to remain muted?
I'm sorry, I was still trying the technology. Am I still muted?
Yes.
Am I fine? Can you hear me now? Can you hear me, Chair?
Yes, we can.
Oh, thank you. Thank you. I'm so sorry. Chair, just the outline of the presentation. There we are. This is my first time before the Standing Committee on Finance, so I thought maybe to speak a little briefly about the Commission and its focus, and then to talk specifically on one of its functions, which is cartel enforcement, which is the conduct that we're dealing with on this matter. And then I will go into the actual matter, which is the stages we would have gone through the cartel enforcement process, which is the initiation of the complaint, and then the investigation together with the findings, and then coming to the point where we refer the complaint and then deal also the leniency processes and the settlement that you referred to in your introduction. And lastly, we will talk about moving forward. What are the next steps on the matter? Chair, as I said, the Competition Commission is a statutory body, and it is established in terms of the Competition Act. It is one of the 3 independent authorities established by the Act, and the other 2, as you would know, Chair, is the Competition Tribunal and the Competition Appeal Court. The Commission is essentially the investigative and enforcement agency of the 3 bodies, with the Competition Tribunal being the adjudicative body and the Competition Appeal Court, as the name suggests, an appellate body that adjudicates matters that the Commission will refer to the Tribunal and the Competition Appeal Court. It is administratively accountable to the Department of Trade, Industry and Competition. It is empowered in terms of the Act to investigate and evaluate all business practices, abuse of dominant position, and responsible for regulating major control in order to achieve an efficient and inclusive South African economy. Chair, just before the Chair, I wanted to share briefly, I won't go into it, what the vision, missions and goals of the commissions are. And I think maybe the bigger one we need to speak of on the vision is that we intend to, we look forward to creating a growing, deconcentrated and inclusive economy. And this we do by implementing the mandate we have in terms of the Act. These are the priority sectors, Chair, on the my right-hand side of the screen that the Commission is it looks into in its proactive work while enforcing the Act. And going now, Chair, onto the actual area of work, which is cartel enforcement. The Competition Act authorizes the Commission to prosecute any contravention of the Act. And those contraventions are then detailed in the Act. One of those would be cartel conduct. What Section 4(1)(b) of the Competition Act sets out what cartel conduct includes. And one is price fixing, market allocation, and the last one, collusive tendering, what we colloquially refer to as bid rigging, Chair. This case, the Forex cartel involves involving the banks concerns both the price fixing and market allocation component of the cartel work. Just in terms of the facts, Chair, the Commission initiated a complaint in April 2015, and it was against a specific number of banks, and those are articulated there. It was Barclays Bank together with some of its divisions, BNP and some of its subsidiaries, BNP and some of its subsidiaries, Citigroup, JP Morgan and its subsidiaries, Investec, Standard Bank Chartered. That is what we refer to as the initial complaint. While investigating, further information came about, and therefore the Commission would have amended its initiation to include the other banks, and including Absa, which at the time was a subsidiary of Barclays. And we then included these other banks, Chair. And these are banks which include not only local banks, but international banks as well. And you will see from their, Chair, they include banks from the US, from the UK, from Australia and other countries. So that is the first step that the commission had to do, was to initiate these complaints. And so what the commission did after initiating, which is part of what the process would be, an initiation kicks in the powers of the commission to investigate the complaint. And so following the investigation, a number of findings come about, and the commission then found that the banks manipulated the USD ZAR currency pair by fixing prices for bids, offer spreads, the spot exchange rate, and the exchange rate at the FIX. The commission also found that, and that is what we refer to as the price fixing component of the cartel, Chair. The second finding related to the division of markets. And here we found that the banks divided markets by allocating customers in which one trader withholds or pulls his or his existing bid or offer from the market to allocate that to another trader to execute and complete his or her trade. And as I said, Chair, this conduct that we found following our investigation is a contravention of Section 4.1b, Roman numeral 1 and 2 of the Act. A number of the global banks have not, that had pleaded, sorry, Chair, just to say, what had happened is that some of this, in this matters, there has been a number of the global banks who would have pleaded in international, particularly in the US, where they would have pleaded guilty or entered into some settlement with the authorities in relation to this conduct in particular. The other issue I wanted to raise, Chair, here relates to the effect, what we found the effect of this conduct to be, which is because of the volume of the Forex trading that happens daily, and because it is so high, and it has happened over a long period of time of at least 6 years, at least on the information we have. This would have exacerbated the effect of the conduct on the currency. However, Chair, as you rightly said at the beginning, the extent of that impact would be what is evidence that would then be presented before the tribunal. So we are not able at this point to speak about that, because that as a litigant, which is before the courts, that is the kind of evidence that would be going there, but that would be going before the competition tribunal at an appropriate time. However, we just wanted to say that there is an impact on the currency. The detail of it will then be contained in evidence at an appropriate time. Following the conclusion of the investigation, Chair, I just wanted here to say that we did engage with some of the regulators, particularly the finance regulators, Chair. We spoke to the South African Reserve Bank, the Prudential Authority, and the Financial Sector Conduct Authority's predecessor, the FSB. And so they were briefed on the outcome of our investigation. It was obviously, and correctly so, Chair, determined that the Commission's investigation and prosecution should take its course, and the matter should then proceed before the competition tribunal as is required in law. Following the investigation, obviously, Chair, we then are required in terms of that pipeline to refer the complaint to the competition tribunal for prosecution. And this entails us drafting legal papers, including what we call a referral affidavit, where we speak or we detail the contraventions and the detail of the facts. Chair, since 2017, instead of answering to the complaint referrals, the banks have sought to challenge the referral, and they've done so for a while. The matter was heard in 2019 before the tribunal, and the tribunal then dismissed the bank challenges to the complaint referral. The banks appealed the tribunal decision dismissing these challenges to the Competition Appeal Court. In February 2020, the Competition Appeal Court delivered its judgment dismissing the appeals of the banks, but also ordering the Commission to file a new complaint referral. In 2020, in light of the Competition Appeal Court's ruling, the Commission then filed a new complaint referral with the tribunal. The banks again did not answer to that referral, to the new complaint referral, and continued to challenge the referral through the tribunal. The tribunal on the 30th of March 2023 dismissed the bank's application and ordered them to file their answering papers to the new complaint. The banks, in response to that, brought appeals and reviews of the decision of the Competition Tribunal, directing them to file their papers. And these appeals and review, Chair, are the hearings that you were referring to that would have taken place between the 13th and the 16th of November. So the hearing that took place before the Competition Appeal Court last week was the hearing to hear further procedural challenges, be them in a form of a review or an appeal by the banks against the decision of the tribunal. Obviously, the Commission is opposing these challenges and would have opposed that at the hearing last week. And so what it means is that as of today, as we speak, the banks are yet to answer to the referral affidavit of the Competition Commission. Chair, sorry, Chair, I think I jumped too quickly. Then, Chair, I thought to then speak about the other participants who have come to some agreement with the Commission. The first one was Barclays Bank, Barclays Capital, and Absa Bank. They have applied for leniency through a corporate leniency program, which allows any party who is first in line to come to the Competition Commission to declare that they were party to any conduct that is prohibited in terms of the Act, to come and declare that to the Commission. And they are then required to cooperate with the Commission in the prosecution of other members to the cartel. So Barclays Bank, PLC, Barclays Bank Capital, and Absa were first in line to do so. So they have been granted leniency from prosecution as a result of that program. The program is very useful, Chair. It's akin to a whistleblower program, but it allows a member of the cartel, which often is impossible to unearth because of its secrecy, to come forth with information to detail what the cartel conduct is, to enable you to prosecute. Then the next two sets are the banks that would have come to the commission to enter into settlement discussions with the commission. The first bank that did so, Chair, was Citibank NA. And as a result, in April 2017, the commission entered into a settlement with Citibank NA, in terms of which Citibank admitted liability and paid a fine of 69.5 million rand. Standard Chartered has now also, Chair, as you are aware, entered into a settlement agreement as well with the Competition Commission, in terms of which it admitted liability and agreed to pay an administrative penalty of 42.7 million. Both of these settlement agreement, Chair, are required in law to be filed with the Competition Tribunal. And this is an oversight that the Act requires the Competition Tribunal to have, so that they can assess appropriateness of any settlement agreement that the Commission enters into with various respondents or parties to litigation with the Commission. So in respect of the Standard Chartered Bank matter, Chair, on the 15th of November, the tribunal had the matter and confirmed the settlement agreement as an order of the Competition Tribunal. In total, the administrative penalty that the two would have then paid amounts to 112.2 million rand, Chair. All the 5 banks, Chair, most importantly, are cooperating with the Competition Commission in prosecuting the remaining 23 banks that are still challenging the Commission. Chair, I also just on this slide wanted to speak broadly about determination of an administrative penalty, because although the penalties that are in a settlement agreement are as a result of agreement between the parties, there is a framework, and the framework is the Act. The Act regulates the factors that you take into account when a tribunal imposes an administrative penalty for any prohibited practice. And so these penalties that we would have agreed to with the parties, that the tribunal would have then assessed, would have been within the framework of the Competition Act. And one of those issues that you take into account is the annual turnover of the firm in the Republic. So the Act in particular, Chair, for first offenders requires that that it provides for an administrative penalty that does not exceed 10% of the firm's annual turnover in the Republic. If you come for you are a second offender, with the amendments that came into effect in 2019, that amount has gone up to 25%. So Standard Chartered Bank settlement penalty of 42.7 million, Chair, would have been within this framework, and it would be taken using the annual turnover of their SA turnover, Chair. Chair, just moving forward, I just thought to say that the matter remains in litigation, as you correctly pointed out, Chair. We still, we are now awaiting the Competition Appeal Court decision on the review and the appeals that have been brought by the banks. And obviously, once we receive that decision, it will determine or guide the next steps that the Competition Commission will then undertake. The Commission will, in the meantime, continue with the prosecution. But, Chair, we just wish to say we do invite settlement discussion from other banks on this matter. Settlement is another tool available to the Commission to firstly curtail long litigation processes and ensure that conduct ceases as quickly as possible and doesn't have a negative impact on the market, and also deals with the resources that we would have. So where other banks are willing to do so, we do invite settlement discussion, but obviously they have to be at a level at which it's still appropriate within the framework of the Act. Chair, I think I will end here and thank the committee for the opportunity. If there are any questions, we will field them together with my team, which is here, Chair. Thank you very much.
Thanks, Madam Tsepe, for your presentation. We'll engage with your report later. Alan, in terms of the agenda, we said who's coming is Treasury.
Yes, Chair. So it's Treasury, then FSCA, and the Reserve Bank also indicated that a representative is here and he will also speak, Chair.
Okay, thanks. National Treasurer, over to you.
Good afternoon, Chair. My name is Bipuso Murisa. I'm the Head of Economic Policy. With me are two colleagues from the National Treasury. The first is Mr. Christopher Axelson, the Acting Head of Tax and Financial Sector Policy. The second is Mr. Vugile Davidson, the Chief Director of Financial Markets and Stability, who will be leading our input this afternoon. But we are all on the call in that regard. With your permission, Chair and honorable members, I'll hand it to Mr. Davidson to take us through. Thank you.
Thank you, Chair, and thanks for the opportunity for us to engage with us on this important issue, as well as to our colleagues at the Competition Commission. Chair, let me start by just stressing that this committee, under both your guidance and your predecessors, have been instrumental in ensuring that the financial sector conducts itself in a manner that is consistent with ensuring a safe and stable financial sector, as well as ensuring that customers are treated fairly. Chairperson, as you've rightly pointed out, and so has the Competition Commission, there are some elements that are still under litigation. So our comments really relate to the specifics of the case that was concluded on the 15th of November with respect to Standard Chartered. And there, Chair, we'd like to make a few broad points, some of which we have made in 2017 when the case was amended by the Competition Commission. A useful starting point, Chair, for us is just to try to get our heads around the nature of the conduct, and it's been just to admit for me a little bit difficult to get my head fully around what exactly was alleged to what conduct was actually committed by Standard Chartered, and the sanctions related to, Chair. But I'll read from the Competition Tribunal settlement document, Chair, which I think gives us a really good understanding of what happened, and that's a useful basis for us to discuss how Treasury has responded in the past and will respond in the future. Chair, 2.6 of the settlement agreement between the Competition Commission and Standard Chartered says that between 2007 and 2013, the respondent, which is Standard Chartered, fixed the prices of bids, offers, and bid offer spreads in relation to spot trades of the rand currency pairs through bilateral and multilateral communication using instant messaging platforms and other communications. Just to sort of unpack this. So in essence, our understanding is that the Standard Chartered set the price in which customers could sell, as well as the price in which customers could buy foreign exchange, as well as affecting the difference between the level in which they bought and sold. And Trevor, I guess very simply that a useful, I guess, real life example would be if one was trying to sell one's car, Chair, the dealer offered you a price to sell your car, which was artificially and unfairly low, or if they're knowing that you want to buy a car, them setting the price artificially and unfairly high. And the bid offer spread, Chair, relates to the sort of margin that bank can make of that transaction. Chair, the settlement agreement goes on to say that the respondents assisted each other through allowing a trader with a large open risk position to complete his trades before trading, and through holding and or pulling of trades to reverse liquidity for each other instead of trading normally in the market. And Chair, my understanding of this is actually something that maybe quite a few of us are familiar with, at least conceptually, in that it closely resembles something like insider trading, knowing that there's going to be a price impact, and then timing your participation in the market to benefit that. So that would kind of be like knowing, overhearing someone, a CEO of a company saying that they've had a really good year and they expect the price to go up, and then timing your trades to take advantage of that. So Chair, that represents our understanding of the conduct that Standard Chartered engaged in between 2007 and 2013. Chair, National Treasury, we should say, and I think that this is something we'd really like to underscore, Chair, views this conduct very seriously, that this unfair market conduct and unfair trading practice undertaken by the offending institutions as being something that is both serious and something that requires and deserves the full force of the sanctions that has been imposed on them by the Competition Commission. Chair, as you've noted, that although some banks have admitted fault, others still are contesting the allegations and are challenging the allegations. And it's important that we allow this process to conclude without fear, favor, or prejudice or undue influence. Chair, the National Treasury will respect, of course, the outcome of the tribunal, and we look forward to the conclusion of the matter. If the allegations are proven to be true, Chair, they would indicate the prevalence, the continued prevalence, rather, of very poor market conduct practices at the time. So this is originating in 2007 and ending in 2013. It is this type of abuse, Chair, that National Treasury had in mind when we undertook a wide range of reforms overseen by this committee and preceding chairs. This included, Chair, the implementation of a policy framework for introducing a market conduct regulator whose mandate in part is aimed at dealing precisely with some of these issues that have been outlined here. Of course, Chair, that was formalized through the introduction of the Financial Sector Regulation Act in 2018 as part of the Twin Peaks reform architecture. The reform put in place a new market conduct regulator to ensure that financial institutions treat their customers fairly and operate with the highest ethical standards. It should be noted, Chair, that the Reserve Bank, the South African Reserve Bank and Prudential Authority are not market conduct regulators, although it's also useful to note that in the immediate aftermath of this conduct coming to light, there was a Reserve Bank investigation as well as establishing a baseline of conduct to ensure that this conduct, which took place in New York, didn't repeat or occur in South Africa. Chair, in addition to the policy framework and the foundational work done by the South African Reserve Bank, and the expression that found in the creation of a market conduct regulator and whose activities included the oversight of both retail and wholesale markets, there have been other regulatory steps that have been introduced by the National Treasury to ensure or to reduce the likelihood of this conduct in South Africa. One of these, Chair, includes draft or regulations, not draft regulations. These are actual regulations which we tabled in Parliament in March of this year. Chair, those regulations relate to the setting of reference rates or benchmarks. And benchmarks, Chair, just to complete the picture, are rates that the market sets that reference a host of other financial contracts and financial instruments. So for instance, Chair, if one had a contract that required a reference to an exchange rate on a particular date, that exchange rate is done in terms of a benchmark. And there has been, including by some of the banks cited in the Competition Commission, some misconduct in relation to benchmarks, and the reforms and regulations that have been tabled in Parliament in March of 23 go to ensuring that certainly within South Africa, the operation of these benchmarks are transparent and in accordance with good practice and financial sector regulation act standards that have been implemented. Looking ahead, Chair, we recognize that more work still needs to be done. That despite the good work that has been established in South Africa as a result of viewing conduct that has taken place outside of South Africa, including the specific case that we're discussing today, we need to ensure that we always continuously seek to improve the system and make sure that the markets operate with integrity. So to that end, Chair, as you may be aware, and the members may be aware, we intend introducing the Conduct of Financial Institutions Bill very soon into Parliament, as well as amendments to the Financial Markets Act soon after that. Chair, my colleague from the Financial Sector Conduct Authority can take you through some of the specifics of, I think, the very important detail of what is contained in the Conduct of Financial Institutions Bill to ensure that our markets operate safely and transparently. But we believe, Chair, that the measures that we aim to introduce there would further enhance the safety and soundness and reduce the likelihood of this conduct occurring domestically. Chair, with your permission and through you, I would invite our colleagues from the Financial Sector Conduct Authority to provide some of that detail, as well as if they would like to, the Prudential Authority of the South African Reserve Bank to provide context on the foundational work that they undertook in relation to ensuring that FX markets operate well and transparently.
Thanks, Vukile. Khona manje wena Vukile, you want to be the chair of the standing committee. You don't invite those who are supposed to present. You want to join Parliament and leave Treasury. So when you end there, I will invite FSCA and the
Oh,
reserve.
Chair. Oh,
No, uvukile ukhathele ukusebenza lapha e-National Treasury ufuna ukuya eParliament. Okay, thanks, Vukile. FSCA.
Chair, good evening, and once again, thank you for the opportunity. Chair, I'm alone today, so I don't have cover, so I suppose I have to properly introduce myself. Chair, my name is Orlando Makhovela. I've joined the FSCA 6 years ago, Chair. I initially was responsible for retirement funds supervision at the FSCA. I've since rotated to market integrity to assist with supervision of markets. Before then, Chair, I'd spent a good 17 years at the National Treasury's Financial Sector Policy Unit. Chair, I don't have a presentation. I have speaking notes. So if I could get to the brief from ourselves, Chair. So, Chair, I thought it would be useful just to start by making some few opening remarks, Chair. So, Chair, as you would know, some of you would know, the foreign exchange currency market is the largest in the world. It is actually larger than the bonds and the equities markets. This forex market, Chair, is generally very deep and liquid with around $7 trillion. And that equates to 132 trillion rands traded daily, Chair. And so if you put that into perspective, Chair, SA's GDP in 2022 was around 4 trillion compared to 132 trillion rands in the forex market, which is trading literally daily, Chair. Having said that, Chair, we do know that the infringements took place offshore and not onshore, so not in SA. Even though we should, as both natural or legal persons, Chair, aim to hold ourselves to the highest standards locally and globally. And I think that's an important point to bear in mind, Chair, that as much as we are South Africans, we are also global citizens, Chair. We also note that the investigations are still continuing under the Competition Commission, Chair, as Mr. Davison had indicated. And we do think and want to state that the Competition Commission is the competent and correct institution to investigate such matters or conduct that is considered to be anti-competitive. Chair, then I want to focus on the period in question, which is the 2007 to 2013. And the timing of events here is important in this matter, Chair. The transgressions took place between this period. And Chair, it is during this period that we did not even have a market conduct regulator in the form of the Financial Sector Conduct Authority, the FSCA. The FSCA, Chair, only came into being in 2018 after the promulgation of the Financial Sector Regulation Act in 2017. Nevertheless, Chair, the National Treasury had already identified various market conduct challenges in the financial sector. And this was very much also following the global financial crisis in 2008. Which to a large extent, by the way, Chair, was triggered by conduct challenges in the banking and mortgage sector in the US. Noting the deemed anti-competitive nature of issues at hand, Chair, it is important to stress that the Competition Commission remains the responsible and best positioned regulatory authority agency for oversight, given also its role and power to enforce the Competition Act. Chair, let me now come to the period 2018 to now. So as indicated above, Chair, the FSCA came into existence in 2018. Our mandate is clear. It is to protect consumers of financial services and products by ensuring that they are treated fairly by financial institutions. Secondly, it is to support the South African Reserve Bank in its mandate to achieve financial stability. And thirdly, and more relevant in this particular case, Chair, it is to support the efficiency and integrity of our capital markets. However, Chair, dedicated legislation is also required for us to deliver on the above mandate. And this has been a process we have been seized with since the FSCA came into being. What this means is that there are some gaps in our regulatory framework, Chair, and these gaps do constrain us in terms of what we can do from a licensing, regulating, and enforcing role. And there are a few areas in this regard, Chair, I would like to share with the honorable members. So when we talk about capital markets, Chair, we are referring to various financial markets like the listed shares, equities market. And obviously what comes to mind there are the exchanges like your JSE, your A2X. Then you've got also your listed bonds and listed derivatives, Chair. And again, just to briefly explain what the derivative is, it is simply a product which is referencing the price of another product. And this would include, for example, your futures and options, which are by standard definition traded on an exchange. So they are listed derivatives. Then, Chair, we have a second market, which is made up of unlisted instruments. And this market is usually called the over-the-counter market. And it's essentially bilateral agreements or transactions between two parties on a particular financial instrument. There are a few of these OTC markets, Chair, globally and locally. The Forex market, particularly the spot market, is one of those examples. The money market, the repurchase agreement market also form part of this OTC markets. And this is the key or one of the key gaps, Chair, in our framework, which is that our current Financial Markets Act does not cover OTC markets like the foreign exchange market, which we are currently discussing. So, Chair, due to the unlisted nature of the OTC market, issues around transparency, fairness, governance, conduct by market participants have come to light globally and locally, with strong calls from international standard-setting bodies to regulate the OTC market. So as an example, Chair, currently we do not have central clearing and settlement of OTC transactions, including for the Forex spot market. So, Chair, just to come to my penultimate interventions, what are we doing and will be doing going forward, Chair? Again, Chair, let me humbly remind the honorable members that we are only 5 years old as a dedicated conduct regulator, but already working and thinking on a number of these issues, Chair. Firstly, we have already started licensing over-the-counter derivative providers. So, for example, if you want to provide financial services in unlisted derivatives, you are required to apply for a license with the FSCA, and of course that will come with concurrence if it's granted from the PA. You would have also seen, Chair, that we have embarked on a process to start licensing crypto asset providers. Secondly, Chair, there was a financial markets review done in 2014 to 2017 of our financial markets, and it came with various proposals. The FSCA, together with the PA and Treasury, are currently amending the Financial Markets Act to include in its definition foreign currency as a security. Currently, we don't have that definition in the Act, Chair. And once this is done, it will give the authorities power to also use the FMA, which is the Financial Markets Act, to supervise conduct of institutions in the foreign currency market. Thirdly, Chair, and in line with the above, the amendments also seek to extend market abuse provisions in the Financial Markets Act to the foreign currency market. Fourthly, Chair, we are proposing a new, broader and all-encompassing definition in line with international standards that will cover both listed and unlisted markets by referring to both of them as organized markets. This could empower us to look at matters beyond those relating to registered exchange-traded ones, Chair. Fifthly, Chair, and Mr. Davidson did touch on this one, Chair, which is the Conduct of Financial Institution Bill. And so this is one area and one bill we are quite passionate about, Chair, because it will, for the first time, provide us with that dedicated instrument to be able to discharge our duty as a conduct authority. And this bill, Chair, is intended to cover both entity-to-entity conduct issues, and these are the issues you are seeing in this price manipulation or fixing matter. But it also goes beyond that, Chair. It will also be covering entity to retail client issues. Six, Chair, we have through the Treasury, and this Mr. Davidson has indicated, also submitted to Parliament this year regulations which will assist us in comprehensively supervising financial benchmarks or indices. And Mr. Davidson has done an excellent job in explaining what these are. So to give you another example, this would relate to, for example, interbank lending rates. And by the way, Chair, some of you might have noticed some of the issues which have come up in the UK around LIBOR and how that was also subject to some form of price manipulation. Chair, 7, we are in engagement with the capital markets on how best we can facilitate the trade reporting of OTC transactions through a trade repository. And this will aid in transparency and surveillance of this complex market, Chair. And Chair, I think by now you would have realized how often I've referenced the OTC market, because we think it's arguably the one area that does require urgent attention from our side. But it happens also to be a quite complicated, complex area too. And then Chair 8, together with the PA at the SARB, we finalized and issued margin requirements for non-centrally cleared OTC derivatives to support financial soundness and stability. And Chair, just very briefly, margins are simply money you put down as a deposit to ensure that you meet your commitment to a derivative transaction. Chair, lastly, we have in 2020 issued a conduct standard for banks, which starts addressing critical issues around the culture and governance. And Chair, I should stress, this point around culture and governance. If you don't have the right people running on a daily basis these institutions, if, for example, the key persons in these institutions are driven by greed, etc., which indeed is a human challenge, then you will encounter, unfortunately, these challenges, Chair. And this is part of the culture of the organization. It trickles down from the top. And so it is quite important that, we have the right culture and governance in our institutions. Chair, just to conclude, we are, together with the SARB and the Prudential Authority, definitely addressing some of these issues. And in the interim, given the complex process of doing legislation, Chair, we could potentially consider nudging the industry to widely adopt the International FX Global Code, which, by the way, the SARB has adopted. Although, of course, one needs to appreciate that it does have some limitations in terms of enforceability, but, there are ways one could work around that. Chair, the period 2007 to 2013 is a period, unfortunately, we did not have a market conduct regulator with a dedicated legislative framework. However, the complex issues that have arisen are also in the competition domain, and we are confident the Competition Commission will deal with them. Chair, thank you so much for your time. I will leave it
there. Thanks, Mr. Makuan. Let's invite the South African Reserve Bank to make a presentation. Over to you, Reserve Bank.
Chair, good evening. By way of introduction, my name is Bafundi Makunoti. I am the head of market operations and analysis in the Financial Markets Department of the Reserve Bank. Chair, I think the governors did indicate to the committee that the SARB is not available to participate in this meeting at the moment. And this is due to some of the post-MPC commitments that it had. And as you will be aware, Chair, that there was a Monetary Policy Committee meeting that was sitting yesterday. So after receiving an invitation to be part of this meeting, we requested that we be given an alternative date, during which time the SARB will then come and make a formal presentation on the matter that is being discussed today. So my presence here was merely to be part of the discussion, well, more to be part of the briefing and understand what the discussion is, so that when we come and have that discussion later, we give a more informed presentation to this committee. With that, Chair, I do wish to indicate that in 2014 and 2015, the SARB did conduct an investigation into the trading operations of authorized dealers. And these are banks that are authorized by the Reserve Bank to trade the rand. And subsequent to that investigation, there was a report that was published on the Reserve Bank website in 2015, and that report covers the scope of the investigation that was conducted by the SARB, what its findings were, and some of the recommendations that were made. Chair, I think I should also indicate that the committee that was given the task to conduct that investigation was or comprised of members of the South African Reserve Bank, as well as the Financial Sector Conduct Authority. I think at the time it was still referred to as the FSB, and the committee was chaired by a former senior deputy governor of the Reserve Bank. The review was largely seen as a preemptive step that was being taken by the Reserve Bank based on observations of widespread misconduct in offshore financial centers. And in those offshore financial centers, I think the investigations that they had conducted resulted in some of the banks that were involved in these practices in the FX market being imposed with large financial penalties. But as far as we were concerned at the time of that investigation, there were no allegations of misconduct or malpractice that was reported in South Africa. And there were also no instances of whistleblowing, as was the case in offshore markets. What we also did at the time, and this was done through the chair of the investigation, is we consulted with a number of overseas regulators to determine that, as part of the investigations that they were conducting at the time, whether the rand was part of the investigations, or that any of the banks that they were investigating or any of the South African banks featured directly in their investigations. And we did not come up with any answers that suggested that that was the case. So in the absence of any allegations of misconduct, the investigation that was conducted at the time looked into whether there was any misconduct or malpractice in South Africa, but also to make recommendations that, in the context of what was happening globally in FX markets, we needed the committee to make recommendations in terms of how the South African market could be strengthened to enhance the integrity and the credibility of our FX market. As I said, Chair, all of this information is contained in a report that was published in 2024. And given the scope of that investigation, there was no evidence of malpractice that was found. But there were some recommendations that were made by the committee. And one of the recommendations that were made was that, in line with what the previous speaker just indicated, that there was a need for South Africa to adopt a code of conduct for these over-the-counter financial markets which are not regulated. But while that conversation was going, and certainly I think there was a draft conduct that was developed, the Bank for International Settlements, through its markets committee, established what we now have as the FX Global Code. And today, the South African Reserve Bank is a signatory of the code. And I think the governor also indicated this during the press conference of the Monetary Policy Committee yesterday, that the Reserve Bank is a signatory of this. And I think an important element of us being signatories of the FX Global Code is that we also made a commitment that all the banks that we deal with in the foreign exchange market need to be signatories of the code, because we believe that the code does enhance the credibility of operations in the FX market to the extent that with the principles that are specified in that code. Lastly, Chair, I also just want to indicate that around the time of the SARB investigation, I'm just not sure if this was 2014 or 2015, we did meet with the Competition Commission under the leadership of the former commissioner. I think it's Mr. Thembinkosi Bonagele. And part of the discussions that we had at the time was the Competition Commission advising us that it was instituting its own investigations. And I think, among other things, that was based on information that the Commission had received from its international counterpart or an international counterpart pertaining to some misdemeanors or misconduct relating to the rand. Chair, that's all I would like to say today. And as I indicated, we have sent a request for the SARB to come and make a formal presentation, and we have requested an alternative date. Thank you very much, Chair.
Okay. Thanks, Mr. Maronoti, for your presentation. We'll look at your request and see how we process that. We don't have much time on our side. We are reaching the end of the calendar year, and next year is going to be quite very short because the Parliament will rise quite early because of the incoming elections. So we'll see how we process your request. But before us here is a report that we are receiving from the Competition Commission that there has been rand manipulation. And I hear you to say that as the Reserve Bank, you don't have any evidence that there was a malpractice. I don't know what you mean. Are you saying what the Competition Commission has found, you dispute it? Or, but let's come to that when we deal with the discussions so that we understand as to what are you saying in actual sense, as much as you are requesting for a day in Parliament to come and make a presentation. Alan, I think we're done with presentations. Now that we're coming to interaction by committee members, is it so in terms of our agenda?
Oh, that's correct, Chair.
Okay. Honorable members, we have received presentations. Let's come to comments, questions from your side. On the platform, I see Honorable Shivambu, Honorable Mabile for now. Over to you, Honorable Shivambu. Mhlonishwa shows Kosana, I can see. Shivambu, over to you.
No, thank you very much, Chair. We want to place it on record that we as the Economic Freedom Fighters raised the issue of the rand manipulation as early as 2017, even issued a media statement to highlight the fact that these financial institutions, including South African banks, are involved in the manipulation of the currency of South Africa. And we called then that there has to be decisive action that must be taken against these financial institutions. And nothing was done. National Treasury went on as if nothing was happening, whilst there was plenty evidence to demonstrate that something else is being done wrongly in terms of the currency manipulation. And this happens against the backdrop that these financial institutions, particularly banks, had assigned themselves the role of being the police or the law enforcer in terms of issues that relate to financial interest of private individuals, closing people's and corporations' bank accounts, sometimes for narrow political reasons and purposes. Now we've got prima facie basis that the laws have been violated by these financial institutions. And these are laws that relate to foreign exchange legislations, the competition laws. And I would think as well that the Banks Act has been violated as well. And these banks have done this purposefully. They knowingly and purposely engaged in unlawful behavior and conduct. The period within which they were engaged in wrongdoing is testimony that they were purposeful in what they were doing. They knew what they were doing. And of course, the impact of what they've been doing has got massive, systematic, and systemic economic consequences and impact on ordinary lives of our people. And there's high possibility, Chair, like if we were to go into what the manipulation of the currency, the sovereign currency has led to, it might have some direct or indirect relationship with the interest rates, which meant that people are paying higher than what was required on their repayments of mortgage or vehicles. There's a possibility that the South African state and private corporations could have paid more for the basic goods and services, including fuel, which have to be imported into South Africa. And therefore, that has got a direct impact on ordinary people, that instead of spending money on food and other essential necessities, now you must pay more for fuel because there is a group of greedy capitalists who are manipulating the currency for their own purposes. Now, on the principle that all of us are equal before the law, I think we need to take the following actions, Chair. Of course, the Competition Commission has said here and publicly that their engagement and the leniency applications and the representations that are being made by other banks does not mean and will never mean that other actions must not be taken. One, this is what has to be done. There need to be a process which we should guide to be implemented by all the relevant agencies, including the Reserve Bank, the Financial Intelligence Center, and all the relevant authorities. One, we should calculate as to just how much money did the banks unlawfully earn from these currency manipulations. How much money did they make? And once we have determined that, even if it's trillions of rands, we must ask for that money to be paid back, all of it, so that we are able to recover. Let's implement retrospective justice. We want all the money that was unlawfully gained by the banks, by First Rand, by Investec, by Standard Chartered, by Absa, by Nedbank, all of that, by the Bank of America, Merrill Lynch, all of those that were involved, by Citibank, all of them, they must have to pay back the money which they unlawfully earned, because it will just be a slap on the wrist if we are just going to say that they must pay the administrative fines which they are paying now to the Competition Commission or to the Competition Tribunal. which is not even a small fraction of what they possibly or have in reality gained from the illegal and unlawful manipulation of South Africa's currency. But the second issue that must be looked into as well should be the wholesale or partial withdrawal of the banking licenses of all these institutions. So if the Banks Act has been violated, we need to withdraw the banking licenses of these financial institutions. All must be equal before the law. And if it is just the foreign currency trading licenses that have been violated, the South African Reserve Bank the Prudential Authority should immediately withdraw the foreign currency trading licenses, must unappoint or reverse the appointment of these banks as foreign currency dealers as of the currency exchange laws that govern South Africa in terms of what should happen. But also because the South African cabinet has characterized this act as treason, as treacherous, the state must now begin the process of withdrawing any banking relationship with all the banks that are involved in these shenanigans. And this must include the banks that have applied for leniency or settlements with the Competition Tribunal and the Competition Commission, so that we then show seriousness that we act with some degree of decisiveness against the wrongdoing that got to happen. And because the first proposal, Chair, that we had made is that there has to be a refund. So the refund must happen even if it's trillions of rands. Let's get that money back. And that refund must trickle down to the refund as well to the ordinary people who got to pay higher amounts of money because some greedy capitalists were busy manipulating the currency. So if we paid more for the car repayments, for the mortgage repayments, let that money, the entirety of it, will be repaid back to the people who were forced to pay more because of a greed of few individuals. And that is what should happen. And of course, there should be criminal prosecution of those that were purposefully involved in this. Whether it's the banks themselves, they must be prosecuted. If it's individuals that are involved, if it's shareholders, everyone else must be held accountable maximally. That is how we're going to sustain the rule of law here in South Africa. This thing that we have got certain laws that are applicable to other people and not applicable to others, it's out of order. It's absolute rubbish. We need to act now, because it looks like the capitalists, particularly the white capitalists and the institutions that they represent, are above South Africa's laws. They direct the state of what should happen. We recently, in the recent past, lost billions of pensioners' money in relation to Steinhoff's misinvestments and misinformation in that particular PIC-involved deal, and nothing has got to happen about it. It can be now a revolving door syndrome where we have got now prima facie violation of South Africa's integrity, and then nothing is done about it. We need to be much more decisive as public representatives, and then take action in the manner that is appropriate. At the core of whatever we do is that all the money that was unlawfully gained by all these financial institutions must be fully repaid to the South African state so that we are able to then cover a lot of the developmental challenges, the fiscal challenges that South Africa is having. I mean, currently South Africa is paying upward of 350 billion rands just to repay the interest of the loans that it has acquired over time, and mostly in the period within which this currency manipulation was happening. I mean, we're owing almost 5 trillion rands to the capital markets out there, and we're unable to deliver basic services to our people, whilst there are people who have been benefiting unlawfully. Let us get the money back so that we can settle our own crisis, and we have some degree of fiscal stability to drive development moving forward. Those are the concrete submissions that we're making, Chair, and I hope we're going to internalize and take that forward. Thank you.
Thank you, Honorable Shibambo. Honorable Matata.
Thank you, Chair.
Thank you, Chair. I'm sitting here and I'm just saying to myself, we are now discussing manipulation of the rent and price fixing done by people. And, I'm just thinking, it will be very much interesting for me to see their job description. What if maybe when they are appointed there, they are being called manipulation of the rent or price fixer, because they just do this without shame and they do this every day. Can you imagine, in the quest of somebody just to want to make a commission or to be rich, they do these things. And who suffers? Our people. We now have endless poverty in our country, unemployment, inequality, and economic exclusion because of this thing. And I hear the presentation today. I've got a couple of questions. I'll just start with FACA. You are talking about that you've been here doing in this job for 5 years. And I'm asking myself, what has been happening before your 5 year? Can we have that? What has been happening? How much have we really lost within that time? And once you find them guilty, because now you are on to this matter, what will be your role in disciplining them? We want to see them. We want to see that. And anyway, Reserve Bank, your recommendation that you want to assist, your request is heard, and the chairperson already, spoken about that one. And Competition Commission, I just have a couple of questions to you. Do you have a detailed report of the money made by these companies contributed to illicit financial flows? Honorable Shivambu has just mentioned something like that. How much? Alternatively, how much of this money's made was shifted to destination outside of the country? Do we have that written down? We hear about the 10%. 10% of how much that they are paying now? It's 10% of how much, considering the years that they've been doing these things. I can imagine, I don't want even to know how much is that, but we really need it written down, how much of that money they have been fixing and manipulating and they gained. And what other measures in the Competition Commission looking into to ensure that some of the banks that they've done this thing, that the money will be using or will be used to support the SME? Because now, what can we do? They might just go there, out there, because we've got a lot of unemployment people, and support the SME and see that they are doing something. Can you do that so that you make sure that it's done? But how much is it? I'm very much interested to know how much. And the 10% that you are talking about, how did you come to the 10% that you are charging? And 10% of what? Really? Oh, thank you.
Thanks, Honorable Mavileta. Honorable Skossan.
Yeah, no, thank you very much. Yeah, thank you very much, Honorable Chair. And good evening to all honorable members and all institutions that are present, the Competition Commission, National Treasury, FSCA, and the Reserve Bank, and the officials from Parliament and everybody present. Yeah, no, Chair, we welcome the presentation from all the stakeholders who have presented. Yeah, it's quite very bad, Honorable Chair. It's quite very bad. On the Competition Commission, especially on this issue of administration penalty, of 10%. I mean, we are talking about this manipulation of our currency through collusion by financial institutions that happened for a period of about 6 years. If you count from 2007 to 2013. Now, if you say that the companies that are found to be involved, the administrative penalty can be imposed, can be 10%, can be 10% or less of their annual turnover. But now the question is, how much did they make, those particular banks? I mean, for 6 years, they've made billions and trillions of rands. And then after that, we say the penalty that can be imposed, it's only 10% of their annual turnover. I mean, after people have made trillions of rands for about 6 years. So I'm really worried if that's what our legislation is saying on this particular issue. But I don't think that is enough, because when you look at the damage that this whole thing has done to the economy and to the citizens of this country. I mean, I agree with Honorable Mabiles and Honorable Shibambo that will be a slap in the wrist. For instance, they say Citibank, I think is it's gonna pay about 69 million rands after 6 years, from 2007 to 2013. They are going to pay only 69 million rand. I think this is nothing compared to what those people they have made. It's nothing, though we don't know how much they've made, but obviously if they were colluding for about 6 years, obviously they've made a lot of money. And to say they can just pay 10% of their annual turnover, I mean, that's peanuts for me. So I'm saying to the Competition Commission, is that all that you can do as the Competition Commission? Or is there gaps in terms of legislations that governs these matters like this? If there are gaps, why are you keeping quiet? Why were you keeping quiet as the Competition Commission? Why didn't you come forward to say, but we think that there are legislation gaps as far as dealing with matters like this? Because I mean, it's an insult to our country and to our people. So is that all what the Competition Commission can do? Or is there something better that they can do than what they are doing now? Because I mean, if this is all what they can do, it means banks they are going to continue to collude, because they know that they can collude and make money for 5 years. If they are found after 5 years, each one of them will just pay 10% or less of their annual turnover. I mean, that's nothing, because they shall have made a lot of money. So I'm saying to them, is that all what the Competition Commission can do? Or is there something better that they can do? If that's all, is it because of limitations in terms of our legislation? If yes, why were they quiet all these years about this kind of a legislation? To say, but we think that there are gaps in terms of legislation. These legislations need to be strengthened in order to be able to deal with challenges like this. And also another question also to the Competition Commission, can they clarify whether this manipulation of the rent may have contributed to the high cost of living that we are experiencing in South Africa currently? And then coming to, okay, also, do they have any details, perhaps, of how much of these companies contributed to illicit financial flows while this thing was happening? Do they have any of such details? And like Honorable Mabiletsa has asked, I mean, would want to know the role of the National Treasury, the FFCA, the Reserve Bank. What will be their role in assisting the country to deal with this kind of a situation, because this situation really, it has affected the country, it has affected our economy, it has affected our citizens. So what will be the role of the National Treasury, the role of FSCA, the role of the Reserve Bank in assisting in remedying this kind of a situation? Thank you very much, Honorable Chair.
So, Togo, Charlie, Honorable Abraham.
Okay, thank you so much, Chair. Thanks for the opportunity. I just wish to join the other honorable members in just welcoming the presentations. We really appreciate it. We know that we called you at short notice. However, you have risen to the occasion. But Chair, I would like to check with Treasury as to what they see as their role. I see that Honorable Skosana is giving them some of the roles that they're supposed to be playing, and whether they do know what they're supposed to do and whether they are doing it. You know, the other question is on the issue of this manipulation itself. You know, do we have some evidence that this is still continuing currently, especially in our country? And I think, we must be able to be vigilant and be able to say, as National Treasury, as SA Reserve Bank, as FSCA, what will be our role going forward in ensuring that what has happened now in our country doesn't happen again? I think it was Honorable Skosana who was saying that this scandal could have had an impact on our current situation, as it were. Now, I just need to just seek that clarity as to whether this thing has not led to the current situation which threatens to collapse the country's economy. Chair, my second last question really is on whether with the monies that are going to be returned by the institutions, the financial institutions that have admitted to wrongdoing and accepted the kind of penalty that they are going to be getting, whether they will ensure that SMEs and other impoverished communities are able to benefit from that. Because one of the aims of the Competition Commission is to really promote employment and advance social and economic welfare of all South Africans. I am interested to know, because each and every one of these institutions have a role to play. We could be discussing this now, while in actual fact, the same is happening, whether it's in a foreign country or inside our country. What is it that we are doing to close the gaps? Thank you so much.
Enkosi, Honorable Abraham, Honorable Mani.
Thank you, Chairperson. I've got bad lighting here, but just three things quickly, Chairperson. Firstly, I greet everyone and also welcome the presentations, etc., etc. First thing, Chairperson, I want to put on record that I want to second the motion raised by the Deputy President of the Economic Freedom Fighters. I think he has made a very progressive submission, and this is a submission that you can see that it's well thought out. It's not anything emotional, and it will help to take us forward. And I think this submission that he has made will also help to get the country out of the grey listing, because this will show FATF that South African Parliament has got zero tolerance on anything that is looks like a shenanigan, as it were. So I want to make a very strong recommendation, secondment, Chair, that all the recommendations that he has made, that we must have a clear program as Parliament or as this committee to make sure that we follow through. That's the first thing. The second question, Chairperson, I have for the Reserve Bank. What does the Reserve Bank think this whole thing is doing to its credibility? I mean, first time around we had a pala thing here, where there was the abundance of evidence of wrongdoing, and there was Reserve Bank that decided to pick just the one aspect that, in their view, was less affected, just to be able to sanitize the whole money laundering that has happened around pala. And yet the Reserve Bank has got a plethora of clauses within the Reserve Bank Act that gives them the responsibility to deal with the issues of money laundering. And because all of that brings in systemic risk and all of that. But they decided to close their eyes on this and said, no, they picked just the one thing and they come up with some wishy-washy technicality of something not perfected and all of that. Doesn't the Reserve Bank think that their conduct, and now we've got this thing here now, which has been investigated by a very competent authority, the Competitions Authority, which has got its own court system, their tribunal. They come with a very clear ruling on the matter, that there is this issue, to your point, Chair, that with that kind of a strong pronouncement from the Competitions Commission, but then you have a Reserve Bank with a straight face coming here today, say we didn't see any wrongdoing. Is the Reserve Bank not part of the problem in South Africa? I think this question must be asked, whether the Reserve Bank that we have, is it part of the shenanigans? Is it part of some big schemes of money laundering internationally? I really think a Reserve Bank requires some investigation here, Chair. We cannot have pala and the Reserve Bank says nothing wrong, and then we have a finding by a competent authority like a Competitions Commission, and then we have a Reserve Bank saying, well, no, we see nothing wrong. What exactly do they see? What exactly do they do at the Reserve Bank, Chairperson, to give us confidence that they are doing things right? Lastly, Chairperson, to the Competitions Commission, I just wanted to just check these 10% of turnover that they do. Is it just the 1 year? Why is it? I mean, if it's just for the one single year, by implication, then it would mean that the Competitions Commission is condoning the thievery that happened for the past 5 years. Why can't we have whatever percentage that we have for all the years that this price fixing, market allocation was happening? I mean, the numbers that is in the public domain now is that apart from the fact that we've just been told that there's 132 trillion traded daily, of that, 1 trillion per day that was made by these banks over the past 5 years. Can you imagine what the kind of numbers that we're dealing with here, Chairperson? And then you have the Competitions Commission that's going to come with some lousy 47 million, 69 million, and out of that. Why don't we have this percentages of theirs, these leniency things, over the entire period? And as the Deputy President of the EFF has said, not that because we're saying this, we mean we'll stop the other processes. We want everything We want zero tolerance on malfeasance. We want zero tolerance on anything that is undermining the integrity of the country. The EFF is on record raising the issue of illicit financial flows. This is evidence that the EFF has been correct from day one when they've been raising these issues of illicit financial flows. This is part of it that we're dealing with here today. So indeed, I think South Africa is very fortunate to have an organization like the EFF that has got a vision and sees things way before other people see them and all of that. Yeah. I think, Chairperson, let me leave it there with those 3 questions, but importantly, that the committee must put a program. I'm endorsing what Deputy President Floyd Shivambu had said, that we then must put a program to see it through. And if I listen to the submissions also by the other members here, members Kosana, Abrams, and so on, I think we might differ on many things, but I think on this one, we are unanimous that we have to act strongly and implement the recommendations. Thank you, Chair.
Thanks, Honorable Mani. Let me also ask questions here. To the Competitions Commission. 1, how have other jurisdictions like the US have dealt or looked into a conduct of this nature? 2, what remedies can be achieved at the end of the prosecution? 3, what has been the impact of this manipulation on the South African economy? Probably there is not the mandate of the Competition Commission to deal with issues of the economy in the manner that I'm asking this question. It is the responsibility in the main of Treasury to explain to the South African public and to the international community that this is the impact that the manipulation of the rand and the dollar has on the South African economy. It has been since 2017 that the matter was filed with the Competition Tribunal. What has been the cause of delays in the presentation? Then National Treasury, you issued a statement on the 24th of November 2023. I'm interested on your last paragraph. On the last paragraph of the statement, you say, however, whilst the wrongdoing described by the Competition Tribunal harmed individual clients, you are not talking about how this has harmed the South African economy. All this week, the past 3 weeks or so, when we've been dealing with the MTBBS, you have been telling us about the South African economy and how we are dealing with the issue of the debt, as Honorable Shivambu and others have alluded to. Now we are talking about individual clients. You say, while this has had an impact or harmed the individual clients, it will not have influenced the depreciating trend of the currency since 2013. The level of which is driven by broader changes in the global and domestic economy. The value of the currency today, which has depreciated against the dollar, and the resulting impact on prices should not be attributed to these instances of misconduct between 2007 and 2013. By this statement, are you defending the wrongdoing of the banks in manipulating the rand dollar? Manipulation, I mean the manipulation of the rand and the dollar. So by so doing, you are not seeing anything wrong in this regard. To you, it's business as usual. a public institution like the National Treasury issue a statement of this nature, and you are the custodian of the fiscus in South Africa. Be that as it may, the minister in the presidency, Minister Khumbudzo Ntshavheni, when tabling the post-cabinet statement, 20th November, she talked about the rand manipulation and the efforts it is having to collapse the South African economy. And to that effect, she said there must be consequences. The presidency say this, National Treasury say, no, there's nothing wrong with what the banks are doing. To the Reserve Bank, you say you conducted an investigation at some stage and you didn't find any evidence of malpractice. But the Competition Commission, which is an independent body, has got evidence before them. And some of the banks, internationally and locally, are actually agreeing that what they've done was illegal to an extent that they are beginning to pay fines. But you come here and say there's nothing wrong that these banks have done, whereas the Competition Commission has found evidence. And you are the institution that is responsible for regulating the financial institutions. You issued them with the bank licenses, and from time to time, they report to you. And all these years, you didn't see anything wrong with their conduct. I think there's something not right. Or are you, what you are doing is that you want to defend high from time to time, there is an increase of interest rate. You are an independent institution. We have never challenged your independence in terms of the Constitution. But the manner things are being done, like the manipulation of the rand and the dollar, has got a serious impact on the lives of the people on a daily basis. As we speak, there are millions of people who are unable, as honorable members have alluded to buy food. Food inflation is very high. We're debating last week. Transport costs are very high. And it is as a result of high interest rates. The other time Kosato was presenting here, was saying that the missing middle is widening. Many people in the public sector, for instance, are unable even to qualify for loans from the very same banks to buy houses, to buy cars, because of their credit rating as a result of high interest rate. Those who have qualified to get loans, they find it very difficult to service those loans. Last week, we were dealing with the two-pot system, where workers have come to Parliament and say, please assist us with the relief. And Treasury brought a bill to say, can we withdraw a certain amount of money from our pension as a result of high interest rates? But you come here and tell the South African public that you haven't found any evidence. Evidence is here before the tribunal or before the Competition Commission. We are going to afford you space and time to come and make a presentation against the backdrop of what the Competition Commission has found. If you have got your own report, you will have to come and report and tell the South African public that this is what you have found. But here, an independent institution called the Competition Commission has found this malfeasance. And as honorable members have alluded, it will be important that there be a breakdown of how much are we talking about here, so that we don't just talk rand, dollar manipulations, trillions have been involved. If the Competition Commission has this information, can you please favor us with that information, so that we don't just speak in general terms. We know how much we are dealing with, and the public know how much is involved here, and see how we take this process forward. Over to you, Reserve Bank, National Treasury, FSCA, and the Competition Commission. respond to the questions raised by members. And can you please switch on your videos? There is a request from the live streaming that they will prefer that they see the faces of those who are responding to questions and those who are asking questions, or those who are participating in the platform. Thanks. Over to you. Let's start with the Competition Commission. After Competition Commission, National Treasury, FSCA, South African Reserve Bank, in that order.
Thank you, Chair. Chair, I'm going to deal with the question in thematical order. The one related to administrative penalty, the 10% administrative penalty, and then the others was on the amounts. I think broadly, that's how I will deal with it, and I'll check with the team where I leave out anything, and they may help me. Chair, I just want to go back. Oh, and then the last issue was how the US dealt with the matter. Chair, I will come to that. So with regard to the administrative penalty, Chair, as I said in the presentation, that is the penalty stipulated in the Act. So when I spoke in that on that slide, I was explaining the legislative framework of the Act. The Act provides that the Competition Tribunal may impose an administrative penalty which may not exceed 10% of annual turnover of the firm, annual turnover in the Republic in the preceding year. So the Act is specific. So whatever we do in the settlement, we may not exceed 10% of annual turnover. So in a settlement, what the section also does, Chair, maybe to go back, is to list some of the factors. The duration will be one of the factors. The effect will be one of the factors. So you take all of these factors into account, but you may not exceed 10%. So the amounts that you're looking at will be looking at it with that in mind. So that is the framework of the law, Chair. And as you know, as a statutory body, the Competition Tribunal may not exceed that amount. To determine all of this, including the amounts, Chair, as I said, that is still evidence that the Commission still has to present before the tribunal. As this is litigation that is still ongoing, the Commission will do so at that appropriate time. And once that process has been completed, Chair, we will be able to come back and inform you. But at this point, this is what we have requested in the referral affidavit, that respondents who are found guilty after the whole litigation is complete, the tribunal should impose an administrative penalty, and we've done so in line with the Act. A question was asked, what else has happened? As I said, there was an introduction of a second level of a higher penalty. And this was Parliament in 2019 recognizing that you need to be looking at you may be looking at another higher penalty with an offender who is not a first-time offender. So looking at this, there has been that component where in respect of a second offender, you may look at a penalty that may not exceed 25% of annual turnover in the Republic. So that is the framework, Chair, of the Act. And as a statutory body, both the Commission, the Tribunal, and the Competition Appeal Court may not exceed those powers. That is the framework we need to work on. But just on the last part, Chair, that in respect of some of the information that we've been requested, that is evidence that we will be leading as a litigant regulator before the Competition Tribunal. With respect, Chair, to the US, also within their legislative framework, this would have been dealt with by the Department of Justice, the Antitrust Division. So most of the firms, I think, that were party to this pleaded guilty to what they call a felony of conspiracy to manipulate the currency, and they paid criminal fines. As far as I recall, Chair. So the last question, Chair, we were asked about the money, where the money is going, and in terms of the Act, Chair, the Act stipulates that penalties to be paid in terms of the Act are paid into the National Revenue Fund. So all the penalties that are paid, they go directly into the National Revenue Fund. But Chair, what I wanted to say lastly is we have investigated, made the findings as required by the law, have put legal papers in place, have placed them before the tribunal. We are waiting for all these legal processes to be complete so the respondents' bank are then able to answer to our affidavit so that this litigation can be conducted before the Competition Tribunal and concluded to test the issues that we have found as is required by the Competition Act. Chair, I hope I have dealt with all of those issues. I'm looking around from my team to see if I have. Thanks, Chair.
So will you provide Parliament with the money, the breakdown of how much is involved that we are talking about here, so that we don't talk in abstract terms?
Chair, I'm sure to the extent that that is in our referral affidavit, I'm sure we can provide that I recall that there is a table in the referral affidavit, Chair, that talks broadly to the forex market, but also to the ZAR currency, and that's where I think, in terms of facts, and that's where I get concerned, to just ensure that we get the facts correct, even us as we present, because it's where information is not clear, that we don't want to, at the time when we come before the Competition Tribunal, that there is cross-examination or challenging of information. So I think I will ask the team to make sure that we get the correct information as we have it in our referral affidavit. At least those are our findings and what we would have provided to the Competition Tribunal. Thanks, Chair. I hope that's fine, Chair.
Yeah, we'll take the matter forward with you because we want the details. We are public representatives. This is a matter of public interest. So those details to us are quite important, so that the decision that we take at the end should be informed by the facts and the findings that you have as an independent body, because you also assist Parliament in playing its oversight role on the financial institutions. Members will make follow-up questions later.
That's fine, Chair.
Okay, thanks. Let me invite the Treasurer to respond to questions and comments made by honorable members.
Good evening. Thank you, Chair, and thank you, honorable members. So I think we've received 3 broad categories of questions. The first relates to what the Treasury is doing to remedy some of these actions and ensure that this type of misconduct doesn't happen in the future. And I will ask Mr. Davidson to speak to those. The second were some of the questions posed by you, Honorable Chair, regarding the media statement released or issued earlier on today. Mr. Axelson will speak to those. And the third speak to the impact of this behavior on economic activity and South Africa's current economic prospects, which I will speak to. So can I please propose or request, Chair, that I allow my colleagues to respond to the first two categories of questions, and I will come in and close off on the third. Thank you very much.
Thanks, Professor. Good evening, honourable members, honourable Chair. I think I'll start. I think the one question that came forward was, what is National Treasury's role in all of this? What are we to do? So the main role that we play is as policymakers, where we propose policies to Parliament to try and reduce this type of activity. So as my colleague Vukile was mentioning earlier, after 2011, we proposed new legislative frameworks so that this type of activity and this type of conduct can be regulated. And that's why our other colleague, Olano from the FSCA, spoke about the setting up of that institution to be able to oversee exactly this type of behavior. So our role is to make sure that there are no regulatory gaps, that firms can't be in a position to make conduct or have misconduct such as this and get away with it. We create the legislative environment so that the financial markets operate efficiently, fairly, and safely, and don't prejudice any consumers or anyone in the economy. So we do those proposals as legislative proposals, and they go through to your committee and to Parliament to try and get through to set up the regulatory frameworks to monitor the banks and other financial institutions. On the media statement, Honourable Chair, we didn't say anywhere there at all that we think there is nothing wrong. We do think there is something wrong. There is something seriously wrong, and we say that in the statement, that we look at this in a serious light and we're very concerned about it. And that is why we have put in frameworks for this type of misconduct, which is unacceptable, to be regulated and to make sure that our regulators have teeth to ensure that this cannot happen and that consequences before some of those institutions where this has taken place. We do not accept it, and we think it is a very poor activity. However, like our previous parliamentary questions we've answered on this type of issue, when we look at the exact type of conduct and misconduct that has taken place, this is on the fixing of bid and offer spreads in the market, in the trading of the currency. And those bid and offer spreads, as we were talking about earlier, are almost like the margin that the banks can make. So the margin that they can put on these trades to then get an additional amount of profit. Nowhere in the findings from the Competition Tribunal does it say that they were pushing the currency one way or the other. They were trying to fix spreads in order to get an additional amount of profit on trades. And those trades could have taken place either way. It could be for clients buying the rand, it could be for clients selling the rand. But then if they fix those spreads, they can make an additional amount of profit on it. So as we've said in previous parliamentary questions, it's incredibly difficult to tell whether there has been any intentional impact on the currency in one way or the other. And since this activity has stopped in 2013, although it is very difficult to tell, the currency market is an incredibly liquid and deep market. And for there to have been any continuing impact from this misconduct where there was no evidence of pushing the currency one way or the other, it is highly unlikely that there are large impacts on the currency today from this type of conduct back in 2013. That is what we were trying to say in the statement, and it reiterates what we said in previous parliamentary questions. That being said, this is unacceptable behavior. It does not treat those customers fairly, and we think the consequences need to take place, and the Competition Commission and Competition Tribunal are the best place to take that action. I'll pass on to my other colleagues. Thank you.
Thank you. Thank you, Chair. I hope my internet is still holding up. Chair, I don't have much to add. I think that all the main points were covered
Sorry, I think there's
by my colleague. Just to reiterate, Chair, about what we've actually done, and I'll just very briefly highlight the steps that we've taken. It's important to note, Chair, that this conduct, which didn't take place in South Africa and took place before we established the regulators, was critical for us to understanding what kind of risks and what kind of bad conduct is out there globally, and then take steps to ensure that in South Africa we minimize the chance of that risk occurring. Of course, Chair, no regulatory system in the world can ensure zero transgression, but we are confident that the intensive, intrusive, and effective regulatory framework we've established will help identify and mitigate any of this conduct should it happen in South Africa. Chair, those steps involve, very briefly, setting up the architectural framework. That's through the Financial Sector Regulation Act, initially drafted in 2014, a year after this, and then passed in 2018, as well as a whole host of subordinate legislation, standards, and regulations, including most notably the regulation that we discussed earlier that was tabled in Parliament in March. Chair, I won't go into what is coming, but in mindful of the need to continuously improve the system, we will be introducing the legislation, hopefully introducing legislation in 2024 to scope in additional activities under the Conduct of Financial Institution Bill, as well as the Financial Markets Act in 2024. Thank you, Chair.
Thank you. We can't hear you, Boipuso.
Apologies, Chair. Am I audible now?
Yes.
My apologies for that, Chair. Apologies for the sequencing issue earlier. I just wanted to come in and reflect on the question asked by the Honorable Abrams regarding whether or not the impact of this behavior or conduct have implications on our economic prospects at the moment. And I think an important place to start, Chair, is at where Mr. Axelson left it, speaking about the timing of the misconduct and what it subsequently means for economic activity now. But beyond that, Chair, I think it's really important to reflect on a few things. The past several years in the wake of the pandemic have seen a significant amount of volatility and uncertainty, both in the global economy as well as in the domestic economy. And what's clear is that South Africa's prospects, growth prospects, not just now, but also over the long term, are significantly and negatively affected by the significant constraints that we have in our economy. We've highlighted in great detail some of these constraints in Chapter 2 of the MTBPS, which you rightly spoke to, Chair, regarding our view of some of the constraints to economic activity, but also regarding our view on some of the solutions that are required to address these constraints. Those are within our control, and those are very much homegrown issues and solutions that we can provide. To give a brief sense of what I'm referring to, Chair, we've spoken in great length in Chapter 2 about the impact both of load shedding and constraints to the logistics sector on economic activity, and subsequently what that means for growth and for employment. And our view has been and remains, Chair, that we need to do three critical things to address some of these structural issues that we face from a growth perspective. The first is to continue to provide a clear and stable macroeconomic framework in order to create a conducive environment for investment and for employment in South Africa. The second is to implement our structural reform agenda, particularly in key network industries that have such important implications for economic activity. And the third is to ensure that the state is adequately capacitated to provide the economic goods and services required to support economic activity, so that we're able to address our constraints in the medium term, but also to ensure that we're on a more robust and a more employment creating growth trajectory going into the future. So I wanted to reflect on those points as well. Thank you very much for your time, Chair.
Thanks. FSCA.
Thank you, Chair. So Chair, I'm on two computers because my one is about to die. Actually, let me just move to the other one.
Gwena, we can hardly hear you.
Sorry, Chair, are you able to hear me now?
Yes, now we can hear you.
Okay, so sorry, Chair, I was just changing computers there. So, Chair, I think for the FSCA, there were three questions. And the first one came from Honorable Dorothy, around, legislation and how can one try and address these issues. And so the tricky thing here, Ms. Dorothy, and I hear where you are coming from. The reality is that we need a mandate to be able to do certain things. And we only got that mandate in 2018. Well, actually 2017, because that's when the legislation was passed. And so what that means is that it becomes very difficult to then go back beyond 2017 and find infringements when you didn't even have the mandate to be looking at particular issues. And as much as Mr. Davison has said that we are currently working on various amendments, even when those come through, they will most likely would apply prospectively. It's one of the core principles of legislation that you can't and should avoid having legislation which applies retrospectively. Because retrospectively, what you have decided is an infringement would not have been an infringement in the past. And by the way, I'm confining this to the conduct within our mandate as FSCA. The Competition Commission has got those powers. They have had the act, and that's why I said earlier on that they are in the best position to be doing what they are currently doing. So that's the challenge, Honorable Member. And then to the question around why this is taking, what have we done in the 5 years we've been FSCA? It's a good question, and from Honorable Skhosana. As I was saying, Honorable Skhosana, legislation is complex and it takes time. And Honorable Chair, you would know this. I mean, in the last 6 years, more than 6 years, the number of bills that we have put through have been quite significant. And there are large bills in there. If you look at the FICA amendments, which literally took a good 2 years, when I was still at the Treasury, the FSR Act itself took a couple of years, given the complexity of the issues and literally the extent of the bill. The deposit insurance bill that you've just processed, the tax laws you have to do every year. So, at one point we were feeling very sorry actually for Parliament and bad that we are bringing, all this legislation and at times it can be overwhelming. So part of it was to see how we can sequence, the legislation, prioritize, because we also don't have all the resources. And as Mr. Davison has said, you will be getting, the coffee bill next year. And hopefully that will be followed by the Financial Markets Act review. Last point, Chair, on Honorable Ms. Manyi, around what is happening now. Again, a good question. So, Honorable Manyi, something which I flagged in my input was around engaging with the industry to see if we can establish what we call a trade repository. So a trade repository is simply a central point of collecting data on these transactions. Currently, we don't have that. So you don't have the data, you can't survey, you don't know what's happening. And so the idea is that once we can set up, this trade repository, then we'll be able to receive data, be able to see what's happening, and together with the SARB and the PA, be able to make the necessary interventions. Thank you, Chair.
Thank you, Mr. Makwe. South African Reserve Bank.
Thank you, Chair, and thank you for hearing our request. And I also note your comment around the timing and the limitations that we have around that. So I'll convey the message. Chair, I think the main question for the SARB from that I suppose I can comment on at this moment is whether the SARB is disagreeing with the findings of the Competition Commission, and whether it is saying that there is no wrongdoing. And I'd just like to clarify, Chair, that we are not disputing the findings of the Competition Commission, nor are we saying that there is no wrongdoing. The comments are made based on the report that was published in 2015, as I made the comment earlier. And I also just want to indicate, Chair, that the investigation itself was a preemptive step that was taken by the Reserve Bank based on what was happening in offshore markets, not because of the specific allegations or incidents of whistleblowing to the Reserve Bank. So that's just a comment I would like to make. I would also just like to indicate, Chair, that as part of the investigation that was done at the time, there were some recommendations that were made by the Reserve Bank pertaining to our legislation. And one of them was that the Financial Sector Conduct Authority should be given sufficient powers to declare codes of conduct as subsidiary legislation. And that was also related to a recommendation that we as South Africa establish a code of conduct for all these over-the-counter financial markets that are largely unregulated. So that was the first recommendation I'd like to mention. The second one was that certain sections of the Financial Markets Act be extended to apply to the foreign exchange market. And those were specifically sections that talk to insider trading, market manipulation, and false reporting. And so we recommended that those be extended to the foreign exchange market in a way that would enable authorities to prosecute individuals for instances of wrongdoing when it comes to these issues. So, Chair, that is where I would like to leave it. And I think maybe the last comment I should make is, as I said, as the Competition Commission was beginning its investigation, there was a conversation that took place between the Reserve Bank and the Competition Commission. And part of it was about how the SARB could support the work that the Competition Commission was doing. And I think, again, this is a comment that the Governor made in his post-MPC press conference yesterday, and reiterated it as a commitment that that the Reserve Bank is making as part of this process. Thank you very much.
Thanks, Mr. Maronoti, for your response. Honorable members, are there follow-up questions? Honorable Mannion, Honorable Abraham, in that order. Honorable Schwam.
Okay, thank you, Chairperson. Just 2 questions. I just want SARB, South African Reserve Bank, to respond to 2 things. One, don't they think that Section 15 of the Financial Sector Regulation Act is triggered by this event, because that section talks to all issues around systemic events, which the Reserve Bank has an obligation to prevent or mitigate those kinds of events. Is that section not engaged in this whole furor of this currency manipulation? That's the first question. The second question is that if you go to the constitution of this country, section 224, that talks to the primary object of the Reserve Bank, that is to protect the currency. Now we have a currency that has been wounded. Now we have a currency that has been depreciated. Why is it that the Reserve Bank does not understand that, which is no doubt about that? I don't know this investigation that does still need to do when everybody knows that the currency has been devalued and all of that, and there's been all kinds of implications about that. But just to narrow the question, the currency has been devalued. Your job is to protect the value of the currency. Do you accept, therefore, that you failed as a Reserve Bank in your constitutional duty to protect the currency? And now that we know who the players are that have done this, why is it that you are dilly-dallying about what is it that you need to do? Isn't the fact that the top leadership of the Reserve Bank is not here, is that not on its own a telltale sign that the Reserve Bank is not taking the people of South Africa seriously? What exactly is going on? So those are the two questions, Chair. The rest is just the top-ups, but those two questions, Section 224 and Section 15 of the Financial Sector Regulations Act. Thank you.
Thanks, Honorable Manya. Honorable Abraham.
Oh, okay. Sorry, Chair. I was just struggling to unmute there. I'm sorry for that. Yeah, I wish to welcome the responses as presented by the various entities. I think, Chair, I raised my hand exactly because I also had a lot of questions to the Reserve Bank. And I think the best we can do for ourselves in this meeting is to have a resolution that says, soon as this committee, let us call the Reserve Bank, because the questions that members have raised here in different ways and tones have largely not been answered the way they should have. But I appreciate some of the responses, but Chair, I want to strongly recommend that sooner than soon, before the end of the year, this calendar year, SARP will have to come before the committee so that they can exhaustively deal with the questions that the members have around the saga. I thank you, Chair.
Thanks, Honorable Abraham. Honorable Shmam.
No, thank you very much, Chair. Look, it's disingenuous of the South African Reserve Bank and the Financial Conduct Authority to now want to just reduce this discussion to the fact that the Financial Sector Regulation Act will not be applicable retrospectively because it was only passed in 2017. There were laws that govern banks prior to this Twin Peaks legislation, which we passed in 2017, 2018, or came into effect in 2018. There were applicable laws which were violated. And there's prima facie evidence now that South African laws were violated. And this includes the Banks Act, this includes the Competition Act, this includes the laws that govern, the laws and regulations that govern the exchange of foreign currencies, the exchange and trade of foreign currencies. This is objectively true. And that we have had financial institutions, the banks that are mentioned, that have gained maximum value, profiteering out of South Africa's currency through unlawful means. Hence, their snitching on each other, they asking for leniency, they're looking for settlement discussions and arrangements which are going to take them out of trouble. We now have to give a clear directive to all the authorities, inclusive of the Reserve Bank of National Treasury, to just establish the extent of the damage that was caused by these financial institutions. And as we said in the initial proposal, we need to quantify. Of course, the Competition Commission is saying that they do not want to disclose or they do not want to speak to those figures now because they are still going through litigation. And if those figures are questioned later as to what they said here and what they said that other side, there might be contradictions. Let's establish and determine as to how much money did each of the banks generate unlawfully from the manipulation of the currency, and all of that money must be paid back. It's as conclusive as that. And then we then go further to check the eligibility of these financial institutions to continue trading foreign currency or to continue holding the banking licenses. After such a treacherous act, which has got a systematic and systemic impact, negative impact on South Africa's economy and fiscal position in general. So that is what we have to be dealing with now. Instead of tiptoeing around these banks, we have to take action as soon as yesterday so that we retain the rule of law. We cannot live in a society where certain laws are applicable to certain institutions and certain people, but are not applicable to certain institutions. Let us, as members of parliament, as public representatives, as those who have been given the constitutional, democratic, and moral right to oversee the executive and to pass legislation, let us make sure that all those who have been found to have done wrong are held accountable, and that all the monies that they've unlawfully benefited or gained from is paid back so that there is some degree of stability. And of course, I think the issue that we might have to deal with is, why isn't the Competition Commission opting for the maximum penalties, which is 10% of the annual turnover of these financial institutions? Because logically, that was supposed to be the case, because despite the fact that the Competition Commission is saying it cannot disclose just how much, but one of the statements or articulations from the Commission illustrated that this amounts to trillions per day, trillions of rands per day. So why are you opting for a lesser slap on the wrist approach to those who applied for leniency and settlements? Let us go for the maximum optimal penalty, which is 10% of the, and that is in as far as the Competition Commission is concerned. And all other agencies and institutions should pursue these banks, particularly to recover the money which was unlawfully gained, so that we can repay the state and repay the institutions, businesses, and individuals who were negatively affected by these developments. We have to be decisive. Let us have the rule of law reigning, because if we're going to have the rule of individuals, we are not going to sustain this democratic project. Let us be decisive, Chair, and stop tiptoeing around these people. We can't go anywhere if the rule of law is substituted for something else. Thank you.
Thank you, Honorable Shmam. Let's go back to the Competition Commission. You want to respond to questions and comments raised by honorable members?
Chair, with your indulgence, Chair, I think Honorable Abrams asked a question earlier which I didn't answer, which was whether the conduct has ceased. And I want to apologize to Honorable Abrams that I forgot about that question. But on the evidence before us, it's that the conduct ceased in 2013, as we have it in our affidavits, in our referral affidavit, Chair. Chair, on the issue of the administrative penalty, as I said, the 10% is the maximum that the tribunal may impose after prosecution. Obviously, during settlement discussion, you go through processes. But I also want to, Honorable Shivambu, to say the amounts referred to in the media, we must remember that in terms of the amount we're looking for is of affected turnover of that firm. So most of the amounts that have been spoken of is of total Forex that would be happening as between all participants. So whereas when you're looking at the administrative penalty, you're looking at the administrative penalty of that firm of affected turnover in the Republic. So then it starts limiting even the amount that you are looking at. So that's what we would have done. And obviously these are settlement discussions where you're also looking to have these parties and also helping you to enter, to be able to prosecute the remainder who wants to continue to fight this matter with the tribunal. I think that was the only issue that remained, Chair. Thank you.
Thanks, Competition Commission through Madam Tsepe. National Treasury.
My apologies for that, Chair. I don't think we had any follow-up questions in this round, but my colleagues can correct me. I think that most of the comments were, not addressed directly to the Treasury, but if we have missed anything, please do flag, Chair, and we can revert.
Okay. FSCA.
Thank you, Chair. Apologies if my background is darker, the building is starting to shut down. So, Chair, just reflecting on Honorable Shivambu's comments, and I do understand where Honorable Shivambu's comments are coming from. All that I'm saying, Chair, is that we as the conduct regulator, because our mandate is quite specific, we only became a conduct regulator, Chair, in 2018. That's when we were provided, with the mandate and the powers to be able to look, into these conduct issues. Yes, in certain instances, there is the legislation, Chair. So, for example, we have the Financial Markets Act, but as I was saying, it does have areas which need to be tightened up. There are areas which need to be tightened up. And in fact, there was, a review of the entire Financial Markets Act, and it concluded actually with a very useful paper from Treasury in 2020. And so we have been going through, the proposals, the recommendations, and hence we are also proposing these amendments to the FMA. And of course, the coffee bill. Again, it is intended to come into effect, hopefully, in the next couple of years. But it will be applying prospectively. It will be applying prospectively. But again, the point I was making, the Competition Act has been there, Chair, from 1998. And that's why I was saying the Competition Commission is best placed, best empowered to look at some of these issues. I will leave the sub-issues and the Currency and Exchanges Act to the sub-chair. All I'm just saying is that as a conduct regulator, I only came into being in 2018. And there's still legislation that I need to put through that will enable me to fully discharge on my duties, and that I can only be able to do going forward. And this is on conduct side, Chair. Thank you, Chair.
Thanks, Mr. Makure. Reserve Bank.
Chair, thank you. I have noted the follow-up questions, Chair, and would like again to reiterate that the Governor will come and address the questions. As I indicated earlier when I started my initial remarks, that unfortunately the Governor could not be in this session, hence there was a request for us to have a meeting at a later time, and this was due to post-MPC engagements, and I suppose the relatively short notice that we had. So, Chair, we would suppose respond to a tentative date that would be given to us to come and answer the questions that have been raised, including the ones that came up in the follow-up. Thank you, Chair.
Thanks, honorable members and stakeholders that we have invited here in this meeting this evening. Let's agree that as soon as possible, we'll have to schedule another meeting where the important stakeholder, that is the South African Reserve Bank, will come and make a presentation in this regard. Because the South African Reserve Bank has got an authority or power to issue licenses to financial institutions, and in particular the banks that we're talking about here, and also monitor their activities. And if there is a wrongdoing on the part of financial institutions, they take action. You have revoked or withdrawn the license of VBS. You intervened in African Bank. And now, if you are not seen to be doing anything on these offenders, it will be looked at as if this is double standard. Why are you not acting on these offenders? Why did you act on small banks like BBS and others? Those are some of the issues that you will have to respond to. So let's allow you to prepare yourself, and then through Secretariat, we'll have to look for a day soon where you will come to Parliament and give the side of your story. In the meantime, let's request the PBO. I think I saw Dr. Jantjies in the platform, or was it in the other meeting?
I'm here, Chairperson.
Yes. PBO, you are a support organ to finance committees. Please go and make a thorough study on this subject. And by the time we have the meeting with the South African Reserve Bank, you make a presentation on the economic impact of this manipulation of the rand and the dollar. Because it can't just that we look at this issue like it affected the clients. Yes, the clients, we are public representatives. We have to defend the interests of those clients because they voted us to be here in Parliament. But we believe that this conduct has had a very serious impact on the economy of South Africa. We're talking about a lot of money here. So PPO, please, as soon as possible, come together, look at this issue, and be ready by the time we meet the South African Reserve Bank, and you present your study that you will have conducted independently. So all stakeholders who are in this platform, when we meet the South African Reserve Bank, you will also be invited. So we'll look at the date with the Secretariat, and as I've said, remember, is it the 5th or the 6th? Parliament will be rising. So in a week or so, we'll have another meeting, a follow-up meeting to deal with this matter that is before us, honorable members. Can we adjourn with an understanding that we'll meet again as soon as possible? Thanks very much to the stakeholders that we have invited. Within a short space of time, you responded and came here to make presentations. We'll meet again, and thanks very much to the support teams of Parliament, the media, and everybody who's in the platform. We'll inform you of the date upon which we are going to meet to further process this matter. This is a matter of importance to the public, and they expect us as public representatives to do something about it. Thanks very much. Good evening. The meeting is adjourned.
Don't leave the chair.
Thank you, Chair. Thank you, Chair. The day is not yet over for us, Chair.
Yeah,
Thank
we're
you,
going-
Chair.
Recording stopped.
Thank you, Madam Tsep. We'll meet again next week.